so much for being here today to discuss the Supreme Court and judicial appointments with us. And I wanted to provide just a bit of background. Many in our audience are not lawyers, so a bit of background on sort of the federal judicial system and why it and Mr. Leo's role in it are so important. So to begin with, we have 6 judicial districts divided up all over the country, 13 appellate courts headed by the Supreme Court. And in those courts, there are approximately 850 confirmed authorized judicial positions, and those judicial appointments are for life. So the president gets to appoint these some 850 judges that are spread out over different presidential administrations, and those justices stay there, justices and or judges stay there for much longer than any particular administration. President Trump, the Trump administration, has been particularly successful in its judicial nominations and appointments. He has a record actually for appointing the most appellate judges in a single year, 12, in addition, of course, to Mr. Neil Gorsuch, Justice Neil Gorsuch, as we just learned about. And I wanted to ask Mr. Leo a little bit about the process and about what the White House considers when they look at judicial appointments for these federal offices. So the White House has mentioned sort of two twin pillars, that of originalism and textualism. And could you tell us a little bit about those judicial philosophies and why they're important in judicial nominees?
Sure. Well, first of all, thank you very much for having me here this afternoon, and thank you to all of you connected with IWF and the important work you do. I've been familiar with your organization for quite a number of years and really commend you for your work and your leadership in bringing women together who believe in our Constitution and our Republic. So this is really great to be here today. When we first sat down with the president and talked about, then the president-elect, and talked about what he wanted in his judges, he said three things, one of which gets to your point about originalism and textualism. The first was he wanted people who were exceptionally well qualified, and that goes without saying. Most presidents seek that. Secondly, he wanted people who were, quote, not weak. In other words, he wanted people who were going to show courage and independence and not be swayed by the social or political fashions of the day. And thirdly, he wanted, and this is a direct quote, he wanted people who were going to interpret the Constitution the way the framers meant it to be. And that was a very, for me at least, different, but at the end of the day, extremely simple and elegant way of describing. I want judges who are going to do originalism and who are going to do textualism. Now really, those are the two key judicial philosophies that have emerged since the early 1980s and have really begun to hold sway in the American legal system. Textualism being very simply the idea that you interpret statutes of the United States the way they're written, according to the plain meaning of their terms, without making it up as you go along. And originalism is pretty much the same thing, except when it comes to the Constitution. You interpret the text of the Constitution as it's written, according to its public meaning, the public meaning of those words at the time of its ratification. And you interpret it with regard not only to the meaning of those particular words, but also with regard to the overall structure of the document, so that you don't interpret one part of it such that it would conflict or be inconsistent with another part. Everything has to kind of fit together. And so those are kind of the big, sort of trendy doctrines of the day, and that's really what the judiciary should be all about. And so that's what the president seeks to have as nominees.
Wonderful. And as you think about sort of the Constitution and the structure of our government, are there certain indicators that this sort of judicial philosophy is what the founders would have expected judges to employ?
Yes. So many of the framers made it very clear that they believed the judiciary was the least dangerous of the branches. In fact, Hamilton talks about that in the Federalist Papers. And so if that is true, then really all judges are supposed to do is interpret and apply the law as it's written. They wouldn't have any power separate and distinct from the other branches other than that. In fact, There are other long tracts in the Federalist Papers which talk about how judges don't have the power of the sword, or they don't have the power of the purse. All they have is the duty to interpret the laws as they're written. And so I think that, in that regard, the framers understood that limited judicial power meant interpreting the Constitution in that way. And that was the practice back then anyway. And that's how people interpreted legal instruments back in the 18th century, going way back before that. But that's not to say that the founders didn't think that the courts didn't have very important authority. Because it's true that the courts are not in the business of making things up and making law. But they are in the business of enforcing that which is in the Constitution. And so ultimately, it's very important to remember that the framers also recognize that our judges have a duty and obligation to enforce what we call the structural Constitution, separation of powers, federalism, checks and balances, limited enumerated powers, bicameralism, all of those different structural features that actually are the most important element for protecting the individual worth and dignity of every person, right? Because it's those structural constraints on government power that give us the space for us to be who we are, and for us to have the freedom and responsibility we need as rational creatures. So they recognized that, and they did understand that the courts had a duty to enforce those features of our Constitution.
Wonderful.
So a weak but not feckless branch.
Absolutely. So in more recent times, if we fast forward until sort of the mid-20th century, we see another sort of governmental structure. I won't call it a constitutional structure, but a governmental structure arising in the administrative state. And White House counsel Don McGahn has suggested that the administrative state is also an issue of concern for the president and the administration, in particular when looking at judges. Can you explain why those two, the administrative state and federal judges, might relate?
Sure. Well, that gets back to what I was talking about with regard to the structural Constitution and the duty of the courts to enforce and apply it. So first of all, I think it's very important to commend Don McGahn, the White House counsel, for drawing attention to this connection, because this is really a first in the political history of judicial appointments. We've never had that connection drawn in such a public, vocal way, and I think that's really important. Now, how is it that they're joined together? Well, if you believe that the courts have a duty to enforce the separation of powers, the idea that each branch has its own sort of respective spheres of authority and they're not to sort of poach on the powers of the other, then the judiciary has a very important role to play in policing the boundaries of the administrative state. So an administrative agency has authority granted to it by Congress, right? And there are two things that one has to care about. One is, has Congress delegated authority to the administrative state or to an administrative agency that agency is allowed to have? Because sometimes, to pass the buck, I know that never happens in Congress, but to pass the buck, hypothetically, Congress might delegate power to an agency that it isn't proper for it to have. It might be lawmaking power, which is really the business of the Congress, not the agency. Then secondly, the question becomes, okay, well, let's assume that Congress has properly delegated authority. Who's going to stop the administrative agency from interpreting its power in ways that exceed what Congress actually gave them? And the big raging debate, or one of them in the courts right now, is to what extent should judges be deferring to administrative agencies and their officers when those agencies assert that they interpret their power in this way, and courts should just roll over and play dead when they offer that interpretation. And of course, my own personal view, and I think this is the view, frankly, of the president, and of course, White House counsel Don McGahn, is courts, by virtue of the separation of powers, have a responsibility to carefully scrutinize agency assertions of authority, because failure to do so would frustrate those distinct separate branches of government.
And we've talked a little bit, just briefly, about the Trump administration's accomplishments in terms of judicial nominations and appointments. I believe as of April 24th, 33 judges and Justice Neil Gorsuch had been confirmed. Again, records in many respects. But there's also, as again of April 24th, 70 judges that have been appointed by the president that are sort of languishing before the Senate committee. And in a recent National Review article identified sort of two structural hurdles in the Senate Judiciary Committee to moving those nominees through to making sure they get a confirmation hearing and then an up or down vote. And those two issues identified were the blue slip process and then the closure process. And to talk about the blue slip process first, could you explain to us what that is and where it comes from?
No, there's literally a blue slip of paper that a senator has to hand in to express his assent or disagreement with a nominee, a judicial nominee. And basically, you check off that you support or you don't support. So any home state senator can do that. Well, what's happened in the blue slip arena is senators still submit their blue slips. But with regard to Court of Appeals judges nowadays, a senator can't stop a nominee from getting a hearing and getting onto the floor just by checking off he doesn't like the nominee on his blue slip. So for Court of Appeals, that's no longer the case. No matter what a senator says there, as long as there's been consultation with that senator, as long as the White House has consulted with that senator and sought his opinion, and there's been some give and take, the chairman of the Judiciary Committee will allow the nominee to have a hearing, even with the negative blue slip by a Democrat senator. Very important development, because in the old days, not having a blue slip meant you never went anywhere. Now, unfortunately, Erin, with regard to the lower courts, the district court judges, blue slips still have sway. So if a U.S. senator there decides they don't like the person being nominated for the district court, they can actually block that person from ever getting a hearing by checking off a negative on the blue slip. Now, that's frustrating, but I think there is a real distinction between the appellate courts and the district courts. The appellate courts are courts that serve multiple states. So to allow one senator to block a nominee who basically will be a judge for many states is just too much power for one senator to have. District courts are a single state. Now, I can make an argument that the blue slip shouldn't be a block at all. That all the blue slip does is inform his fellow senators that he likes the guy or he doesn't like the guy, and let the whole Senate vote on it. And that's Senator McConnell's position. Senator McConnell's position is that's all the blue slip ever was. And I happen to think he's right, but that's not quite where we are right now. Now, the second thing is the closure process. Unfortunately, Democrats are requiring 30 hours of debate for every judicial nomination. And there's just not enough time every week of every month to spend 30 hours on every judicial nominee and get other business done. And so that's the holdup. They're moving as best as they can, and it's true that by the end of this week, we'll have more judges confirmed than President Obama did in the same amount of time. He had 2. We're going to have, 20, 21, somewhere in that neighborhood. So things are looking pretty good right now on the appellate level, although at some point we're going to hit a bottleneck. And the fact of the matter is the district court judge numbers are abysmal, right? That's where the 30 hours is really doing this in. Because you got to get your appellate judges confirmed before you get your district court judges confirmed. Those appeals court jobs are really, really important. A lot of law gets made in those courts, which most cases don't see the U.S. Supreme Court. So unfortunately, that's where we're losing a lot of time and traction.
Great, and could you just speak to that last point just a little bit? Of course, we're all familiar with the United States Supreme Court and many of the cases it hears. But why are the appellate courts and the federal district courts, why are all of these important positions we should care about?
Well, I mean, look, the Supreme Court hears, 70-some cases a year? I don't know what the number is now. It's 70s or maybe very low 80s. At its out of thousands and thousands and thousands of cases that make their way to the federal courts. So the Supreme Court was never a court of correction overall, and it's much less so now than it's ever been before. So the courts of appeals become really where the rubber's going to meet the road for a lot of really important issues. And there are a lot of really important issues that are never going to see the courthouse doors up there on Capitol Hill in the U.S. Supreme Court. So that's why this is so important. The district court judges, really important too. What's happening in the Trump administration right now? Nationwide injunctions, right? From a few select district court judges around the country. We've never seen this trend of stopping government action nationwide as a result of a single plaintiff in a single case in a single district of the U.S. district courts in the United States. We've never seen that. There was only really a couple of other cases before this administration where we saw real abuse of that process. We're now seeing it with much greater frequency. So these courts are important. They have real consequence in our lives, and that's why it's so important to move forward and transform the judiciary as quickly as we can.
So now I want to ask you about a topic that I'm sure many in the room will be curious about, and every year about this time, you know what I'm going to ask. We hear rumors that Justice Kennedy might be considering retiring. And of course, it's impossible to read the tea leaves. And of course, I'm not asking for any inside information. But we do know that if you...
Of course you are.
Well, a little bit. But if you look at sort of the trend among justices, they tend to retire, not always, but they often tend to retire sort of out of a sense of loyalty during the administration that appointed them. So Justice Kennedy was appointed by President Reagan. They also tend to make this retirement, at least the announcement of it, within the first 2 years of the presidential term, probably on the idea that they want to take politics out of it as much as possible and give the president and the Senate time to nominate and confirm a replacement. So any thoughts you can give us on a potential retirement?
Well, first of all, I think I need to start on that side because there's a lot of money to be had here, obviously, because I get this question all the time. Well, first of all, Erin, you've hit the nail right on the head. So basically, you've got a court that served together for a very, very long time. And you've got a number of individual justices who in their own right have served for a very, very long time. And so it would be foolish not to be thinking about the possibility of the retirement. And of course, anyone involved in this business, in the White House, outside groups, Senate, so forth, on both sides of the political spectrum, they're thinking about it a lot right now. Because the demographics and the sort of statistics in terms of the court service right now are very ripe for the possibility of a retirement vacancy. So that's natural. Will it happen? Well, there are really two windows when these things occur. We passed through the first one without a doubt, and that's sort of at the very end of April, mid to late April. A lot of justices historically have announced their retirements then. That didn't happen. The second time period is from the very end of the term, usually around June 28th, June 27th, June 30th, thereabouts, till about July 3rd. And there are other justices, quite a number, who have also chosen to retire then, at the very end of the term. You don't see a lot of activity between April 30th and June 30th because that's the busiest season of the court. As you know, having been there, quote from the chief. I mean, that's when all the justices are getting their opinions done, circulating drafts, and people are writing dissents, and so on and so forth. So, you generally don't see retirements during that time frame. So I think we're on a watch right now until the end of June to see if anybody will retire. But I think in light of the current makeup of the court and how long it served together, I think it's something we should be watching pretty closely and potentially preparing for.
And if there is a retirement from Justice Kennedy or one of the other justices, are there particular areas of the law that you think might shift?
Well, Justice Kennedy has played very important role in a lot of different areas of the law. So on issues like federalism and separation of powers and some aspects of enumerated powers and freedom of expression in terms of limits on political speech, Justice Kennedy's been very much an originalist and a textualist. He's cared very deeply about those issues the way many of us in this room probably do. On other issues, issues like race and voting, Erin, I would say he's probably been, sometimes on the one side, sometimes on the other, more of an incrementalist. Not that you would know the law better than I would in those areas, but I think that's a fair characterization. And in other areas, particularly on some of those really core social policy issues involving life and family, he's been more with the liberal in the court. So there's something there for everybody to love, and there's something there for everybody to hate. And so at the end of the day, this is going to be a big fight, because everybody is going to try to be defending the turf that they have and trying to expand it. And so that, I think, is how this process will be defined. And certainly that sort of more checkered jurisprudential outlook affects the nature of the process. Yes, it will add ugliness to the confirmation. But I'll tell you, Erin, I have to be honest. Does anybody in this room really think that if some justice who was decidedly conservative across the board or decidedly liberal across the board, that somehow that confirmation process would be quieter and more so? I don't think so. I think we're at a point in our history where both sides are playing for keeps, and sure, maybe on the margins, the Kennedy vacancy creates a little more intrigue and a little more controversy, but at the end of the day, I don't think it's really on the margins. These are fights for one's life, no matter who the vacancy is.
I think sort of to wrap up here, we've done some research here at IWF concerning sort of what's important to voters. And we were surprised, even I was surprised. I'm very much a court aficionado. I love the law and the ways that it interacts with our lives, maybe the ways it shouldn't interact with our lives. But I was surprised to learn that the Supreme Court, for one of the first times, was one of the top issues in voters' minds going into the last presidential election. So I wanted to ask your views as to whether that's a trend that you think will continue, whether the court and the judiciary might continue to be prominent in voters' minds, or if that was unique to Justice Scalia and then the political situation at that time.
I think there are two factors that probably contributed to that. One was certainly Justice Scalia's passing, and that was a major event in our history in the country. And you may remember that Justice passed away on the day of the very first Republican presidential primary debate. So we were really in the midst of presidential election season. But secondly, it was a really big issue because President Trump made it a big issue. He made it a really big issue. First of all, by coming out with a list. I mean, we now have a new standard for every presidential candidate. I will bet you that there will never be another presidential candidate who can get away with just saying, I'm going to appoint justices like A and B. I don't think the American people are going to say that's enough anymore. They're going to want to know what's the range of people you're actually going to appoint. Show us the list. And I think it'll be very interesting to see whether we have a new trend here. I think we could potentially. So it was also just the way President Trump teed up the issue. So what happens in the future? Well, my hope is that candidates take their lead from what happened with then candidate Trump, and that they make this issue a defining issue of future presidential races. It really is one of the president's most enduring legacies. And it really is, as Senator Mitch McConnell said, something that's at the very, very top of the Senate's agenda in terms of importance. Mitch McConnell has said on a number of occasions this year and late last year, at the end of the day, the Senate's really in the personnel business more than it is anything else. And I think he's right. So my hope is that it will stay at the top of the 23% of the American people who voted in exit polls said that the court was the most important issue for them. And amongst Republicans who voted, it was 59% or 60% thereabouts. So those are big numbers, and we've never had numbers like that before. The numbers generally hover around 13, 14%. So this is a big deal.
Well, thank you so much, Mr. Leo. You actually stole my line. I was going to say, in a recent Economist article, actually said that the judicial appointments and nominations, confirmations, will likely be the Trump administration's most enduring legacy. And we owe much of that to your guidance, so thank you.